Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So the other day I asked the question about women in Wisconsin. And I said, what is it with all these gals in Wisconsin that are going to trial? Because we had the Shabusiness case and the Lori Phillips case and then the eye drop poisoner case, Kerchevsky. And it occurs to me that I may have been a little rash. I left someone out. I think we could have said the very same thing about North Florida. While Florida man has become a meme, I think Florida woman is becoming one. So we already know that Dan Markell was murdered in Tallahassee, which is in North Florida, and that was an artifact of a bitter custody dispute following a divorce. The two killers, the facilitator, and the brother of the ex-wife, have all been convicted, and very soon the mother-in-law will face trial in Leon County. But that's not the only murder arising out of a North Florida divorce involving angry wives and hired hitmen. It almost blows the mind. But in the early evening of February 16, 2022, Florida police officers responded to reports of shots fired on a street in Jacksonville Beach, and there they found Jared Bridegan, dead with multiple gunshot wounds, lying next to the open door of his VW Atlas. Jared had been driving home to St. Augustine from Jacksonville Beach, where he had just dropped off his 9-year-old twins, a boy and a girl, from a previous marriage, and he dropped them off at their mother's house. Bexley, his 2-year-old daughter, with his wife Kristen, was in the back seat of the SUV. She had witnessed the whole murder and, other than just seeing her father shot, she was otherwise unharmed. Police had this belief that because there was a tire in the middle of the road blocking the vehicle's path, that maybe Jared got out to move the tire and that's when he was shot. And I think that's pretty much what they concluded. So the route that Bridegan was driving was one he'd taken numerous times before when dropping his kids off at their mother's house. So anybody who knew his routine could have taken advantage of it. The question then sort of becomes, well, who knows what his routine is? Well, after the murder, investigators sought help from the community in locating a dark blue Ford F-150 four-door truck that was caught on security cameras from businesses in the area around the time of the murder. This is something I think that killers don't understand very well, is that you don't have to be caught on video pulling the trigger. If your vehicle is caught in the area, you're going to come under suspicion. And indeed, that's exactly what happened here. So the Jacksonville police described this murder as a ruthless homicide, and it almost destroyed Jared's family. Finally, after about a year's worth of investigation, they arrested a guy by the name of Henry Teenan. Henry Teenan, as it turns out, is the former tenant of the current husband of Bridegan's ex-wife. And that is the person who they believe conspired with Teenan to murder Mr. Bridegan. And eventually, Teenan and the husband and the wife were both arrested and charged with, among other things, second-degree murder, accessory after the fact to a capital felony, and child abuse. And the child abuse comes from the fact that the 2-year-old witnessed her father being killed. The cops had this suspicion that Henry did not exactly act alone, and in March and again in August, that's when they arrested Bridegan's ex-wife and her current husband. They were charged in the murder. The case has been progressing, but it has recently hit a snag. The phones and computers of both the husband and the ex-wife have been seized. They were seized with a search warrant post-arrest, and their contents were downloaded for examination by the state. This is routine. They always do this. And yet, people who plan murders still use their computer. They search for things on Google like how do I poison someone? Or what's the best caliber of gun to shoot someone in the head with? Things like that. Those are the kind of things that they search for, and they leave a trail of breadcrumbs right back to them. So smart people who plan murders, not that there ever have been one, I can't imagine anybody in recent years who has been smart enough to get away with murder. I guess maybe you could say Casey Anthony did, but the jury didn't convict her of murder. They convicted her of being a liar. But I digress. The bottom line is there's all kinds of valuable information in the phones and the computers, but, and it's a big but here, there's also information that may be considered privileged. And that's where the state's case has hit a pretty good-sized bump in the road. Both husband and wife had retained counsel well before their arrests because they were questioned, and they weren't going into those exchanges without a lawyer. There were emails and phone calls between the lawyers and the suspects that were marked as confidential communications. In order to get around this, the fact that the computer held both valuable information that would be evidence in the case, as well as protected information that shouldn't be disclosed, the defense asked for a protective order from the court, and the state's response to that is, we'll set up a Taint team. Now, a Taint team is a group of disinterested cops and lawyers who get together and they review every document in the production from the computers and the phones in order to determine if those documents are somehow protected by an actual privilege. Why do they do that? Because there could be numerous privileges involved. There is a communications privilege between a husband and a wife that's governed by the marital communications privilege. Emails between the two could be privileged. In both civil and criminal cases, communications made between spouses during the marriage are privileged if the communication is intended to be private and made in reliance on the sanctity of marriage. Even if the marriage terminated because of death or divorce by one of the spouses, the privilege can still be asserted. In some states, it's held by the person who, each person holds it independently. So, if the husband didn't want the wife testifying against him, he could assert it. And if the wife didn't want the husband testifying against her, she could assert it. But because both parties hold the privileges, in some states, it is up to the spouse, the other spouse, actually, as to whether or not they wish to be bound by that privilege. So it's not a rule that is uniformly enforced, and so there's law on both sides, which makes it an interesting case. In the majority of jurisdictions, like I said, it's held by both spouses, and any party can assert the privilege. The burden of proof's on the opposing party, in other words, in this case, the state, who has to prove that the particular words and acts are not intended as a private communication. That's going to be hard to do, but that's also not the end of the story. In addition to this, if a lawyer asks his client to prepare a summary for his review, that is protected by the attorney-client privilege. If a lawyer says, hey, give me your movements on the day of the murder, and he writes this down and there's a 4-hour gap, well, again, that's the kind of thing that might be useful evidence, but if it is sent to the lawyer, it is also privileged. So anything that is a communication between the lawyers or where the lawyers are copying their clients with privileged information, none of that stuff should have been in the hands of the state, and the state can't use any of that to prosecute the case. In this case, the defense is saying the state gained access to these confidential documents and that as a result, the assistant state's attorney should be disqualified from further action in the case. Now, this is where I apply the DeWitt rule. And the DeWitt rule applies to all court filings. And the DeWitt rule says, wait to decide if something is a problem until all the facts are in. So right now, we don't know what the state is going to say about this. It could be a misunderstanding. It could be something completely different. But they told the newspaper the state will file appropriate objections to the defendant's motion and is confident it will prevail after full consideration by the court. Now, you might wonder how that could be if there's confidential communications. Not everything that is found in that computer or a phone might be marked confidential. It might not have that marking. For example, let's suppose there's a document that the defendant is worried about. Maybe it's an angry letter that the ex-wife sent to Bridegan, and they send it to the lawyer to ask for his opinion or to make him aware of the letter, and they mark it a confidential communication. Even if they mark it as confidential, the fact that it was shared with others waives the privilege. It can't be converted into a privileged document if it was sent to someone else, like Bridegan. So just being marked confidential doesn't mean anything. They might very well have documents marked confidential that are not, in fact, confidential. Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe. And if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you. And let me pause here to tell you that having recently been in litigation with some big DC-based law firms, they mark a lot of stuff confidential that's not confidential. In fact, it just could never be confidential. But that's another war story for another day. Similarly, even though communications between spouses are normally considered privileged, the burden is on the state to show that they are not. But to take a step back, let's look at how the privileges are construed by the courts. Courts always construe privileges narrowly, meaning that because they're in derogation of truth, meaning that they keep the truth-finding process of the court from coming out, they are considered to be narrowly construed. So when someone tries to use a privilege to commit a crime, usually the law doesn't permit that. So a text between husband and wife to the effect of, "Hey, good news, honey, hired a great hitman who used to rent from me," that text might not be considered privilege, and a court would need to decide. Now, again, the things that really are privileged should definitely not be in their hands. Taint teams are nothing new. I've seen them used in other litigation where there's a possibility that privileged documents might get into the wrong hands. For example, in a False Claims Act case where someone is an insider inside the company and they have documents and emails that were sent around and back and forth that may have gone through a lawyer at some point, well, some of those communications might very well be privileged, and they might not necessarily show up as privileged if you don't know that the person on the email chain is a lawyer. So one of the things that the defense did in this case is they sent to the state the names and addresses and email addresses, obviously, of all of their lawyers. So if the email was sent to Jane Doe at Oh Boy, Do We Cheat 'Em and How, they would know that that email is definitely one of the lawyers in the case. And as a result of that, they would not look at that email. But again, just because there is a communication between lawyer and client doesn't automatically make it a protected communication. It has to be communicating in confidence and sending facts and seeking a legal opinion. So, for example, just because your lawyer sends you a copy of the menu from Ristorante Felonia with duck soup circled doesn't mean that the menu is privileged. Because to be privileged, it has to either seek or express a legal opinion or otherwise be in search of a legal opinion or legal advice and that sort of thing. Big tobacco lawyers used to suppress thousands of pages of material that were not privileged in any respect just by copying their lawyers. And when they were asked to provide discovery, they would write up a privilege log of, document 14159 and put on there that it was communication from an attorney. But when we started going through a lot of the material during the state's tobacco trials in the late 1990s, what we found was that tobacco lawyers had marked the U.S. Surgeon General's report as privileged, which it clearly wasn't. So all of that brings us back to the question of what happens if the state's attorney in this case is disqualified. In that case, the governor appoints an attorney from a different circuit, and that attorney brings himself or herself up to speed, and the case just goes forward. In other words, even though you might be able to get the prosecutors disqualified, it's not a get out of jail card. So that's what I have for you today. Hopefully you found this interesting, helpful, useful, something that maybe you didn't find other places. Thank you so much for paying attention and for all of the comments that I've received and all the new subscriptions. If you're a new subscriber, thank you very much for coming on board. Please feel free to join, ask questions, and do the things that everybody else does here. It's a great group of people, and I think you'll find that the community here on this channel does some really good commenting and has some very interesting opinions. So thanks for watching. If you have the opportunity today, do something nice for somebody. And then come back here tomorrow and visit with me, and we'll see what else we can talk about. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.